Meeting to order. Has appropriate meeting notification been given?
Yes, it has.
All right, we're going to start with item number 2. I just need a motion from somebody to approve the minutes of August 24th, 2022.
I move that we approve the minutes.
I second.
All in favor?
Aye.
Aye.
Wonderful. Okay, we are moving right along to committee business, the first of which is to consider act on recommendation to council on the outcome of Zoom call with Attorney Andrew Campanelli regarding municipal ordinances overseeing wireless installations. So we have Mr. Campanelli on our Zoom call at this time. Thank you so much for joining us. We're really glad to have you. What would you prefer that we call you? Andrew, Mr. Campanelli?
Andrew or Mr. Campanelli are fine. Can you hear me?
Yes, we can. Maybe,
Yes.
maybe the volume could be a little louder, guys? Yeah. And then would you prefer, I know you will, we're going to have Jill Persick, one of our committee members, sort of introduce you and your background. But as we go along, would you prefer that we ask you questions as we go or wait with questions until the end?
No, I prefer to ask questions as we go so I can try to explain them to the best of my ability.
Okay, wonderful. So I am going to turn it over to Jill Persick now, one of our committee members.
Great. Hello, Attorney Campanelli. I was the one that contacted you, and it's really an honor to hear from you tonight, so thanks for reserving this time for us. I was introduced to Attorney Campanelli by the founder of Wisconsin for Safe Technology, who is actually in our audience tonight. And I've had for years a concern that communities aren't doing enough to protect residents from the various effects of EMFs, and found out that you've been working with cell tower issues since 1996. He's licensed to appear before the Supreme Court since 1998 and 9 of the 13 district courts. So I will let you take it over from there.
Okay, well, to introduce myself, yes, I've actually been a litigation attorney for 30 years. I've been handling cases under the Federal Telecommunications Act of 1996 and wireless facility cases since the act was adopted in 1996. I've handled cases across the entire United States. Ms. Persick was right. I'm admitted to 9 of the 13 circuit courts of appeals. I'm admitted to more than 9 district courts across the United States. So what I do is I do represent local governments. I represent individuals in 2 manners. Number one, I represent them when they seek to prevent the irresponsible placement of a wireless facility in their jurisdiction. And increasingly, local governments are hiring me to draft local zoning ordinances for them that vest them with the maximum power to control the placement and number of wireless facilities that are getting built in their jurisdiction. Within the context of the 5G rollout, the battle to prevent the irresponsible placement of wireless facilities is more dramatic than ever. The problem is not necessarily the carriers like Verizon or AT&T. They're the site development companies. These are companies that don't provide any actual wireless services. They build wireless infrastructure and then they lease space or capacity on the infrastructure to the wireless carriers. Every single time I get a call from someone asserting that a company is trying to put a cell tower literally on their front lawn, it's always a site developer. And so I'm trying to make sure that local governments are made aware of the fact that, contrary to what they're generally told, they have broad powers to control the placement of wireless facilities. The key to exercising the power is to take hold of the power that Congress specifically preserved to them in the Telecommunications Act. To take hold of that power, what local governments need to do is to draft a comprehensive wireless ordinance, which A, grasps the power that Congress preserved to you, and number 2, incorporates procedural guidelines for your local planning or zoning boards to follow to make sure that if and when they choose to deny an application for a wireless facility, they do so in a manner which does not violate any of the procedural requirements of the Telecommunications Act. So that's the quick nutshell. So I'd welcome any questions. I mean, I can explain whatever you'd want, but I'd like to know what it is you're looking to accomplish. I can tell you what I've done, what I can do, and go from there.
Okay, Jill has formulated most of the questions comprehensively for our committee, so I will let you start with the questions, Jill. And if you have any questions, just
One
speak up.
question I have is, we've been told that our state strips local governments of our rights. So how does your ordinance navigate both the state and federal laws. We're under the impression that Wisconsin law really restricts what we can do, and for the length of time I've been speaking about wireless, I've heard that phrase, our hands are tied.
Right. So the Wisconsin law, if I recall correctly, and I haven't read it for about a year, I don't memorize all, I haven't memorized all 50 local laws. But if I recall correctly, the Wisconsin law affects the ability of local governments to regulate the wireless facilities being installed in public rights of way. Now, the state laws are the most dangerous. They're what I call hoodwink laws. Representatives of the wireless industry go to state legislatures and they trick them. I call them hoodwink laws. They literally deceive them into adopting laws which strip local governments, I should say, more power from local governments than they actually intend. The reason I call them hoodwink laws is they are presented to the state legislatures as laws which are very limited. They're only supposed to apply to the installation of physically small wireless facilities. They're only going to be installed on existing utility poles on main roads, and that's how they present it. But then they draft ordinances that ultimately get adopted after a whole lot of political contributions are thrown around the state legislature. And they incorporate definitions which make the restrictions much broader than the state legislature actually intended. For example, they will define the statute to say it only applies to public rights of way. And they'll say that limits it. But then in the definition of public rights of way, definition will include areas on main roads, adjacent to main roads, near sidewalks, and even public utility easements. That's not by mistake or omission. Public utility easements include, for example, electric easements. If you own a home and you have electricity and you're not off grid, there is an electrical easement across your property. The wireless companies and site developers claim they should be recognized as public utilities. And every single time I've seen them put a cell tower literally on somebody's front lawn, they claim they have the right to do so because of a utility easement. So Wisconsin does have a hoodwink law. It's not as bad as some others I've seen, if I recall correctly. If I recall correctly, also, it primarily affects small facilities, I think in public rights of way, which leaves a broad area in which you can regulate the installation of wireless facilities. Now, if and to the extent that the broadest code possible for you might in some way conflict with the state law, I draft survival provisions. I do it for two reasons. Number one, a survival provision says, okay, we're drafting all of these provisions in our ordinance that says we can control where these things go. The survival provision says, if and to the extent that any provision of this ordinance in any way conflicts with federal or state law, that section of the ordinance shall not apply, but the balance of the ordinance does. Now, why would you do that? Well, for two reasons. Number one, to the extent that someone, meaning a judge, interprets the state law more narrowly than a site developer would try to claim it works, your ordinance would control. But the other thing is that there is across the nation a groundswell of opposition coming up. Every time someone sees a cell tower installed right in front of their front door, 5 feet from their daughter's bedroom window or on their front lawn, they're starting to scream and yell, and they're starting to reach the state legislatures. And I think that some of these hoodwink laws in the future will be amended, if not repealed. Now, if there's a provision in your state law that restricts your ability to do something, and that law gets repealed, again, the only way you have the power to exercise control is if at the time of the repeal, you already have an ordinance in place. Otherwise, after the state law gets repealed or amended and leaves more room for you to regulate, you must now draft a new ordinance. You have to do public notice or public comment. You have to have a public hearing. There's a whole process you go through. So when I guide local governments, I say adopt the ordinance. Make it as broad as possible within reason. But of greatest import, make sure that if and when you design applications for wireless facilities, you comply with the procedural requirements of the Telecommunications Act. For 30 years, I've watched towns get sued under the Telecommunications Act. And I've read all the decisions where a judge said they violated the act because they did this, or they didn't violate the act because they did that. All of those case decisions are built into my ordinances. And it goes circuit by circuit. When I draft an ordinance for a local government in New York, it's different than for a local government in California. I take into account the federal case law of your circuit, plus your existing zoning code, your existing zoning districts, your topography, your population density, your historic preservation areas or districts, any aesthetic resources, any historic resources, all of that gets built into the code. My average zoning ordinance for wireless facilities is about 47 pages single spaced, but it's not designed to stop wireless facilities. It's designed to give each local government the absolute maximum powers preserved to them by Congress, and to make sure that if and when they exercise it, their exercise of that power is as immune from challenge as possible. Again, as a litigator, I don't want my municipal clients to get sued. And especially if they get sued, I don't want them to lose.
Thank you. Any follow-ups on that one?
Andrew, this is Andrew Maroney on the committee here. And when you talk about the ordinance being as broad as possible, what are some types of things we could put in that ordinance, just from a general perspective, moving forward?
Okay. There are three types of major wireless facilities. There are the actual macro towers, which are the big cell towers. Small cells, which are typically just facilities that are physically shorter in height. And then the distributed antenna systems. They're called distributed antenna systems, which consist of DOS nodes. Unlike the first two, these are systems that don't work independently. You have to install multiple nodes. This is the majority of the 5G rollout. Site developers are going into residential neighborhoods, and in some cases, they want to install DOS nodes every 150 feet. And again, some of them are ridiculously close to homes. So the first thing you do is you draft an ordinance that says if you want to build a wireless facility, you need to get a permit. The most common types of permits are use permit, special use permit, conditional use permit. Sometimes they also need a site plan approval. And sometimes if they don't meet height restrictions or setback requirements, they have to also get a variance. Normally the process works where somebody applies for a permit, there's a publication of notice. You make nearby property owners aware that this is pending. And then there's a public hearing before a board. It could be a planning board, planning commission, ZBA, and you make determinations. Now, under the Telecommunications Act of 1996, one of the constraints that impose upon local governments is that any denial of an application for a wireless facility must be based upon substantial evidence and must be denied if it's denied for a legally permissible reason. It also must comply with 3 or 4 procedural requirements. The reason most local governments get sued is because their planning board or ZBA, when they're deciding an application, never comply with the procedural requirements of the Telecommunications Act because they have no idea that they exist. And I guarantee your code is exactly the same. You have to your local board can make factual determinations, but your local zoning code must give them the power to make those determinations. Now, there's 2 types of determinations they have to make. The first are determinations under your code. In most sophisticated local jurisdictions, they draft code ordinances that empower their board to deny applications for wireless facilities based upon the potential adverse impacts an irresponsibly placed tower will inflict upon nearby properties. There might be adverse aesthetic impacts, reduction in property values, an insufficient fall zone, or granting the application might be inconsistent with smart planning. The smart planning provisions, like the ones I draft, are not designed to stop cell towers. They're designed to achieve 3 objectives simultaneously. First is to enable carriers to saturate your town with coverage, but at the same time, minimize the number of facilities you need to provide that coverage. And third, avoid to the greatest extent possible any unnecessary adverse impacts on residential neighborhoods and individual homes. To do this, your board has to be guided to make factual determinations. The first type are your local code determinations. Will the proposed cell tower have these adverse impacts? Does it have a sufficient fall zone? Is it consistent with smart planning? Meaning, if there are gaps in service, will this remedy the gaps? Or if not, are we gonna have to put up 2 towers or 3 towers instead of 2? But of equal import, perhaps greater import, when the site developers come in, they say, this tower has to go up because Verizon has a gap or AT&T has a gap in its wireless services, and this is the least intrusive means of remedying that gap. Now, why do they make those representations? They make them because one of the other constraints that the Telecommunications Act imposes upon local governments is it says local governments cannot effectively prohibit carriers from providing personal wireless services. Well, how do they prove that a denial of a specific application would violate the Telecommunications Act? They have to prove 2 things to the satisfaction of your board. Number 1, that there exists a significant gap in a carrier's personal wireless services. And number 2, that their proposed tower at the specific height they want it, at the specific location they want it, is the least intrusive means of remedying the gap, and there are no potential alternative, less intrusive locations. If your code doesn't guide your planning board or your ZBA, number one, to tell them that they must make those factual determinations and guide them as to what to consider and what evidence to require the applicant to produce to enable them to make those determinations, you're throwing your planning board to the wolves. They have no chance of rendering a decision for which you won't get sued and won't lose. That's the biggest problem going on right now. Local boards are not provided with the guidance they need to apply their zoning code without violating the Telecommunications Act. And every time some local municipal attorney gives them guidance when they have no idea what they're talking about, they follow the guidance and they get successfully sued because the municipal attorney had no idea what they were talking about. The municipal attorney says, well, we tried, but the Telecommunications Act ties our hands. No, your hands were tied because your code did not provide guidance to your local board. Even worse, in 90% of the applications I see across the entire United States, applicants knowingly submit false materials, patently false, but the board has no idea. For example, one of the things they submit is an FCC compliance report within which they claim that the facility, if built, will not expose members of the general public to radiation levels which exceed the levels that have been deemed safe by the FCC. Across the country, I see them submit false FCC compliance reports. When a planning board sees it, it might as well be written in Sanskrit. They have no way to know what's false and what's not. My ordinance gives them guidance in plain English, tells them exactly what to look for. So these are just some of the things that go into my ordinances. Again, not designed to prohibit wireless services, not designed to ban 5G or anything like that. It just gives the local government the power to deny each and every application or to grant them on a case-by-case basis.
Thank you.
I hope I didn't put you to sleep with that one.
No, that was, that was fabulous. Thank you so much for that. I know Jill has some more questions here. Ron, anything? Peter?
Attorney Campanelli, we do have public hearings for cell tower permits, and the city planner sends out notices to property owners within 200 feet of cell towers. I don't think we require a certified mail and return receipt, but I've seen you advocate 1,500 feet with certified mail and a return receipt. Is that common in your ordinances, and
Well,
do you
actually,
require
what I'm
that?
doing is, it depends upon the density, because sometimes, your lot size may be 50 feet by 100 feet. It may be 3 acres. I don't know. I don't know what your zoning lot sizes are. So it varies from jurisdiction to jurisdiction. I've also told local governments perhaps to avoid the certified mail return receipt requested. More of greater import is what's put on the envelope, and I'll tell you exactly why. Across the country, smart local governments say to the applicant, okay, we're gonna have a public hearing. You have to send out notice to all property owners within 300 feet. One of the newest games they play, and it's disgusting, they will send the notice and they will give you a copy of the notice they sent. But what they don't give you is the copy of the envelope. And the envelope is designed to make sure that the recipients don't open them. Here's what they do. They will send the notice in an envelope. The outside of the envelope will have a return address of a marketing entity. It may say, the return address may say XYZ Marketing Corp of Denver, Colorado. It will then be addressed to occupant at that address. And for a stamp, they won't use an actual stamp. They will use an ink stamp that says bulk postage permit paid. It is guaranteed that every person who receives it immediately thinks it's junk mail and throws it out. It's not by mistake. This is what they're actually doing to make sure nobody shows up for the hearings. So what I do is, in my ordinance, it says you're going to send out this notice, but the notice is going to say on the front, in font size that's all bold and at least 12 point, notice of public hearing for proposed new cell tower or wireless facility. It has to say it on the outside of the envelope so they can't pull that stunt in your jurisdiction. Those are the kinds of things that go into my ordinance, because I've seen everything they've done. I've seen them lie to local governments, threaten local governments, and I am fiercely protective of the local government who seek to enlist my services. I make sure that you're not going to get tricked, you're not going to get bullied, and Congress legitimately preserved to you the power to control where these things go. And my goal is to make sure that you are capable of exercising the powers to the maximum extent Congress deliberately preserved them to you.
I think that our city planner and our municipal attorney would actually be thrilled and relieved to have something like this in place, because both of them admittedly amazing and intelligent men that do great things for us, but that there are some areas of this that we've just not been able to pin down or get clarification on, or be able to function in the way that we would like to as far as these applications. And we've seen the letters that come through. And I've always wondered on those, how do they really prove that they're getting that okay from the FCC? And part of that is the fact that they haven't updated their studies since, what, 1996? Yeah.
Yeah, and that issue is being litigated right now. It went up to the DC Circuit Court of Appeals for the DC Circuit. So there are two problems, actually a number of problems. So let's talk about health concerns of RF radiation, because that's what residents always want to talk about. One of the constraints that the Telecommunications Act of 1996 imposed upon local governments is a provision that says local governments may not regulate wireless facilities to the extent they are FCC compliant. What does that mean? It means in most jurisdictions, you cannot take into account health concerns if the applicant proves that when the installation is built, it will not expose members of the general public to radiation levels which exceed the levels which are known as the general population exposure limits. Now, here's the problem with that. You're not allowed to talk about it. But number one, the limits are not actually enforced. Once the facility is built, the FCC never tests the radiation emanating from these facilities and never requires the owners to test them. And the wireless industry knows that. So we've had facilities actually exceeding the FCC's limits by as much as 1,000%. And that is dangerous. Everybody acknowledges it's dangerous. So what do? Smart local governments, and it started in California, have adopted random testing requirements. The code provisions provide that at any time, the town can get an RF engineer and test the radiation level being emitted from the facilities. And if they find a facility exceeding the FCC's limits, they can either fine them or, better yet, schedule a hearing to revoke their permit and require the tower be ripped down. At the hearing, the applicant has to show cause why you should not revoke their permit. And the cause they'd have to show is that the equipment malfunctioned. It's not a case where they powered up, which is what they do, but the equipment malfunctioned. The three first cities who did that in the beginning were the cities of Burbank, Berkeley, and Davies that adopted provisions like this. Now, what does it cost to test, and do you have to test? Some engineers will test for as little as $400, and you don't have to test every facility. Let's say there's 20 facilities. The fact that you have the ability to randomly test is usually enough to make sure that they stay FCC compliant, because no carrier wants it to come out in a local paper that one of their facilities was tested and found to be exposing people to radiation levels which exceed the levels that have been deemed safe by the FCC. So simply by putting that provision in there, you're protecting people.
And
As far as whether or not the levels are safe, my personal opinion is the levels are not safe, and they're going to be found that they're not safe. But that determination is not going to be made for at least 5 to 6 years. That's what I think.
and how often, in general, are municipalities testing with an RF engineer?
It's entirely up to the municipality. You know, there's several different ways you can do this. One of the first times I was involved was the city of Calabasas in California. And in their code, they adopted what I call a key time provision. It actually deputizes every citizen. Any citizen can get an RF engineer and test any facility at any time. And if they find the facility emitting radiation levels which exceed the permissible limits, they have the right to sue that company in court. And if they prove that they exceeded the FCC's limits, the owner of the tower has to pay them their attorney's fees. Now, most local governments don't adopt that type of provision. Most of them say, we have the right to test. Some of them push the envelope a little bit and say, you know what? We have the right to test the facility once a year and to pass the cost on to the owner of the facility. That's something that's a little more dangerous in terms of possibly getting sued by the owner of the facility saying you can't do that. You're now regulating based upon health, and that violates the Telecommunications Act. On the other hand, if they sue you in federal court for that and they win, they don't win damages, they don't win attorney's fees, you don't pay them a penny. The federal court just says, yeah, your ordinances, that portion of your ordinance doesn't work, can't use it. The safest way is to just say, we can test and we'll eat the cost.
Do you have some more questions?
Ticked off a number of the questions I was going to ask.
Ron, did you have any questions at this point, or Peter?
That's very, very cogent and concise and understandable. Thank you.
Now, one pushback that I've heard is that I understand if we're sued, that we wouldn't have to pay the penalty, but we would just revert back to what the original request was. But what do you say to city leaders that are concerned about the out-of-pocket, the out-of-pocket money that they would need to front to sue and then pay in the first place?
Okay, so first and foremost, as I mentioned earlier, when I draft these ordinances, I take into account the law of your federal circuit. There are 13 United States Circuit Courts of Appeals across the country. These are the courts, the appellate courts that are just below the U.S. Supreme Court. And so each time I draft an ordinance for a local government, I look at the federal case law of that circuit and how federal judges have interpreted what local governments can and cannot do under the Telecommunications Act. So I draft it to try, to the best of my ability, to make sure that any action you take is within the confines of the law, the federal law in your circuit. Then I also, again, include procedural guidelines to make sure when you exercise that ordinance and your rights under the ordinance, you comply with the requirements of the Telecommunications Act. So what happens if you deny an application and you get sued nonetheless? And by the way, it used to be when the board followed my instructions and set up a proper record and made a decision and complied with the procedural requirements, that was the end of it. Nobody'd ever sue. However, in some cases, some site developers are suing. They're filing federal lawsuits, even if they think they can't win, because they want to try to get the town to come to the table to try to work out a settlement. But again, let's say for argument's sake, you get sued in federal court. What happens? It's always the same. And I've been in federal courts, chambers across the country. The judge immediately gets both sides into his court and says, let's get together, see if we can settle this. And the first thing the judge says is, okay, you want to build a tower, you turned it down. Is there a way can we resolve this? Can you make the tower shorter? Can you put it in a less intrusive portion of the site that you want to put it on? Can you put it on an alternative site? Is there a site that both parties can agree on? If the parties cannot come to an agreement to resolve the case, typically the carrier says, we filed our complaint, we want to move for summary judgment. And the town says, we didn't violate the Telecommunications Act, we want to move for summary judgment. And so the judge sets up a schedule, says, okay, you're both going to file motions. These cases do not take years, they take months. And it's really very simple. It's motion practice. Each side, the court will say, okay, each side's going to file their motion within 30 days. And then each side gets to file opposition papers to the other side's motion. I'll give you 2 weeks for that. And then both sides get to put in a reply 2 weeks after that. So you put in 3 sets of papers. Then the judge and the local government submits the record. Whatever record the planning board or ZBA had before it when it made its decision, they submit the record. The judge gets the motion, looks at the record the board had before it at the time it made the decision, and decides if you violated the Telecommunications Act. If you did, judge issues an order saying, give them the permit. If you didn't, the judge dismisses the case. If you lose, you pay no attorney's fees, you pay no damages, you don't pay a penny. What about the cost of your own attorneys? Here's the way I describe it. These cases, in my experience, are the least expensive federal lawsuits I've ever encountered. It's accelerated motion practice. The only danger is if you hire a firm who realizes they represent a municipality and thinks their job is to milk the municipality for as much money as they can get out of it. Because all they're doing is filing a motion and opposing a motion. That's it. It's not going to cost $100,000 or $200,000. If it does, you hired the wrong law firm.
Fair enough.
It's about as plain English as I can give it to you.
Thank you.
Are there any questions that anyone here has? I would entertain any questions that you would have for Mr. Campanelli. Elaine, Mayor, Mark, anybody? Oh, Ron
Okay.
has a question? Okay.
Yeah, I have a question. So let's say the tower is emitting radiation at excessive levels. If without an ordinance, can the city be sued by a citizen who brings that charge against is there liability on our behalf if we don't have an ordinance?
Well, as a general rule, I would say no, although it would depend upon the law of your state, and I am not admitted to the state of Wisconsin. I'm admitted to the federal courts in the Eastern District of Wisconsin. But what you're supposed to do is if you find a facility exceeding the FCC's limits and you don't have any provision in your code which empowers you to do anything about it, the only thing you can do is file a complaint with the FCC, which in most cases will ignore you. There are cases where people have documented a facility greatly exceeding their limits, exposing people to really high levels of radiation. And the FCC did nothing. And they would file the same complaint with the FCC for the same facility 3 and 4 and 5 times. And it's only after it was documented 4 or 5 times that the FCC finally did something and fined the owner like $10,000. Didn't make them rip down the facility, but the facility could then, a year later, be found exceeding the FCC's limits all over again. Okay. Many people describe the FCC as a captured agency, and my personal opinion is I tend to agree with them. Captured meaning the FCC is more likely to do the bidding of the wireless industry than protecting local governments.
Yeah.
So the reality is this, here's the way I put it. You are your citizens' first and only line of defense against being exposed to illegally excessive levels of radiation. That's the best way I can describe it.
Good way to put it. Elaine, it looked like maybe you had a question. And I'm not sure, is there a microphone right there? Is this mic on right here?
Oh, okay, just right there, okay.
Hi, Attorney Campanelli. I'm Elaine Ugger with Wisconsin for Safe Technology. Although I haven't served too much in that role recently because I am now a local elected official in the village of Greendale here in Wisconsin. Have you drafted any ordinances for any Wisconsin communities?
I don't believe I have. The most recent ones I've done in 2022, I've done, I don't know, at least a half dozen in New York. I've done them for Langley, Washington, Dalton Gardens, Idaho, City of Calabasas, California, one for Pennsylvania, but I don't think I've done one for Wisconsin yet.
Okay, could you talk a little bit about the wireless radiation and who you think is a good authority on the safety issues? I know I personally would not turn to the American Cancer Society, the FCC, the FDA, and for people in this room who think that wireless radiation is not harmful, what are your thoughts on that? Because I truly believe it is harmful. Could you tell us what you've found?
I have to take off my attorney hat because now I'm going to give you my personal opinion. And
Thank
let me
you.
preface this by saying I'm not a scientist, I'm not a doctor, I'm certainly not an activist, I'm just a lawyer. But there was a time that I represented a site developer, helping them put towers up. I also negotiated leases for wireless facilities. Then came a time when I switched sides, and I will never ever help somebody put them up again. And the reason is, I become aware of what I perceive to be the clear evidence of adverse health impacts from exposure to the RF radiation from these facilities. I read studies from around the world. I spent a year, before I stopped representing a site developer, I spent a year reading every study I can get my hands on. And I became constrained to draw 2 conclusions. And those conclusions are this, my personal opinion. If you live within 1,500 feet of a cell tower, your odds of getting cancer leukemia go up 300%. And the segment of the population that is most susceptible are children. That's my personal opinion. It's not an unfounded opinion. I base that on a lot of studies, a lot of expert opinions. And I will tell you that anecdotally, every week, I get 3, 4, 5, 6 calls from people who are getting sick for exposure to RF radiation. Now, some people are acutely sensitive. I have a case currently pending before the Ninth Circuit Court of Appeals, where a person owned a condominium on top floor. They put a cell antenna about 6 feet above his bedroom. Within a month, he got deathly ill. He had to move out. His doctor told him he showed classic signs of overexposure to microwave radiation. I argued that because he is EMS sensitive, he is disabled within the meaning of the Americans with Disabilities Act. I demanded reasonable accommodation. The carrier and the city, which is the city of Millbrae, argued that they can't make a decision based upon health because it's precluded by the Telecommunications Act. The federal court in the Northern District of California dismissed the case. It's now going up on appeal before the Ninth Circuit Court of Appeals. There are both people who have increased sensitivity, meaning there are some people whose biology is such that they are not adversely impacted by levels of radiation which don't affect the majority of us. They are EMS sensitive. There's no question they exist. However, when a facility is exceeding the FCC's limits, there's no question that there are harmful adverse impacts because people call me every single day. The problem is that getting the FCC to change the limits, which at the time they were adopted in 1996, were 10 times higher than the limits adopted by other countries. To get them to change it is going to take litigation for years. They are in the same position, in my opinion. They're in the exact same position that tobacco companies were decades ago when they used to say, there's no definite evidence of approximate cause between smoking and cancer. It's the same thing.
Thank you for your question, Elaine. Anybody else have any questions for Mr. Campanelli? Yes, no? Okay. So where do we go from here? As a committee, we need to make a recommendation to our council to consider hiring your services. So that could still take a little time, between now and our next meeting, et cetera. But I know you've talked with Jill about compensation and your procedures, et cetera. What can you tell the rest of the group here about that? Like timing,
Okay, so
et cetera.
sure. So the way it works is I charge a one-time flat fee of $8,500, which is peanuts because it usually takes me 20 to 25 hours to draft the ordinance. I have to review the circuit case law of your circuit. I have to review your local zoning ordinance. I have to review any comprehensive plan. I have to study your zoning districts, your topography, your population density, and then I draft an ordinance, which typically is about 47 pages. And the way the process works is I draft the ordinance. It may take me 4 days or 5 days. It may take a few weeks if I get too many in at the same time. Then I provide a first draft to the municipality. Once I provide a first draft, they discuss it. They disperse it among themselves, their legislative body, their planning board, their ZBA. They may send it to the county for input. And then people have input. Sometimes they suggest alterations or changes. Then I would work on the alterations or changes. Very often I'll have a Zoom meeting with the legislative body. Sometimes it includes the planning board or the zoning board, so I can answer any questions they have. So there's usually several meetings. And then once we get it drafted to a point that I'm comfortable and the local government is comfortable, then you go through the adoption process, whatever it may be. You publish notice, you publish a copy of it, and there's a public hearing. I then also attend the public hearing to answer any questions the board may pose for the public. So usually, in addition to the actual drafting, I'll spend anywhere from 3 to 6 hours basically explaining how everything works. So that's generally the process. But I draft the ordinance not to impress anybody. It's drafted in layperson's language. So number one, if it's ever challenged, a judge is going to understand it. It's not difficult. But of greater import, your planning board and your ZBA doesn't need a law degree to understand how it works. It's laid out in clear language.
Okay, thank you. Any other questions before we let him go?
Maybe one last question.
Yes, Peter.
Sorry, I came in a little bit late. My name is Peter Haft. Pleasure to meet you. How would this have any bearing on the telecom systems that we currently already have within the community? Are they grandfathered in because they came before our provisions, or what happens with that?
Well, much of that would depend upon the law of your state. I don't know how the grandfathering law in your state works. Again, I'm not in the state of Wisconsin. Certain things could apply. For example, if they tear it down to put up a new one, your new code would apply. Substantial expansions may be covered. Even if they're compliant with the FCC at present, I think your random testing requirements could still be applied because at any time they exceeded the FCC's limits, they're now operating illegally. So you could apply it there anyway. You should also understand that, I don't know if you're familiar with the Middle Class Tax Relief and Job Creation Act, which gives the owners of these facilities to increase the height or power output or add equipment exempt from local zoning laws. I don't know if you're familiar with that, so I'll tell you what it is. In 2012, President Barack Obama signed into law the Middle Class Tax Relief and Job Creation Act of 2012, which by the name of it wouldn't make you think it had anything to do with cell towers, but there was a wonderful silver bullet hidden in there. And here's what it basically says. Once a wireless facility is built, the owner of the facility can increase the height of the facility and add equipment and add power output, as long as the increase of the facility does not significantly increase the overall size of the entire facility. The FCC has interpreted that to mean they can increase the height by up to an additional 20 feet and the local zoning boards are powerless to stop. Sorry, Ms. Mayor, did you have a question?
No, I think we're good. Oh, no, we're good. Someone was leaving. Okay, well, that's good. Is there anything else that you want to share with us before we let you go? And then we'll discuss this as a group as far as taking action, making a recommendation to send this on to council.
No, I think that's the main gist of it. I also tell my municipal clients to take my phone number. You have a question, you pick up the phone, you call me. I don't charge anything. Again, I protect my municipal clients. I've seen the carriers come in and threaten local boards, intimidate local boards, mislead them, and then walk out and laugh about how gullible they thought they were. So I am fiercely protective of local boards. So that's the best I can tell you, and that's what drives in part what I'm doing. So I very much appreciate the chance to speak before you. I hope you found it helpful, and whether you choose to enlist my services or not, my offer to accept phone calls from you guys remains open. So
Wha-
with that, I'll take my leave, and I thank you very much.
One addition before you go, you had agreed to, I told the committee this, you had agreed to, once we bring this to our common council, if they have questions, well, we would present it to them, and then you agreed to be on a brief call with them if they're left with any questions before making a decision.
Yes, I would have no problem. I'd also, if that was to happen, I'd also want to take a look at the Wisconsin law again, refresh my recollection. Again, it's been about a year since I looked at Wisconsin's law, but I want to be able to have an intelligent, well-informed conversation with them. I always make sure I know what I'm talking about, so I'd want to look at that before that takes place. But yeah, sure, no problem.
Okay.
Well, thank you. This has been very informative and very eye-opening. So we thank you very much for that. Have a wonderful evening.
You as well. Good night, everyone.
Thank you.
Thank you.
Thank you.
Wow.
Pretty thorough.
So I guess what I'd like at this point is a motion for us to recommend that we send this on to the Common Council for consideration.
I'll volley that motion.
Okay,
Okay, I'd second that.
all right. All in favor?
Aye.
Aye.
Very good. I'm very excited about this. Okay, so on to, I think we approved the minutes. We got to A. Let's go to B, 3B, committee business, update from committee member Jill Persick on monitoring wireless frequencies in other communities. We had tasked her with that at the last meeting.
Well, I'm just still amazed at everything that he said. And he took my thunder a little bit because he described what not building biologists, but what engineers can do. And I'm thinking that that is in his ordinance, you know, that those provisions are in the ordinance. What I really found was that there's not like a governing body to just come up with, oh, let's just call this place and get their certified expert to come out. There's plenty of resources and there are plenty of people to call, but I didn't find that communities were using that, you know, that were actually enlisting people. I think still there's a kind of an uneducated notion about the wireless technology in people's communities. And I think most of the public is really more uninformed. So there's not this aggressive, he mentioned California has set up some now regulatory bodies that can, you know, that can enlist experts to make measurements. So there is the Building Biology Institute where you can find an expert, but those experts mostly measure in-house. You know, they measure homes and businesses and schools. There is a site called emfexperts.com. There is one certified expert listed. Her name's Mary Bloomer. I've spoken with her. There's also a person who lives out of around Chicago, Mika Jacobs, and I've spoken with her. She's an EMF service provider. She's not she's not certified in the way that the EMF experts certify people, but she has like $20,000 worth of equipment. She's got a degree from Yale. She knows her business. So it's sort of a hunt and, so it's kind of a hunt and peck issue about who to get from where and what are their certifications, what is their education and background. So there's not really a centralized business model. The price ranges, and he mentions sometimes what the price is. To go to a home, it's like $150. Someone said for a 20,000 square foot, not to exceed $250. That was from the Wisconsin expert, and they do readings for people outside their homes. So, you know, if a school or business wanted to do that, you know, they'd be able to do that. And the cost goes up. I was warned by some of the experts I talked to that there are companies, for example, like Shielded Healing Company does EMF home surveys, but that's $997. So there's a kind of a burgeoning interest in the industry for presenting yourself as an expert, and the costs vary a lot. So it's not a really regulated area of service, and there's people that will take advantage of communities that want to, you know, get measurements. I did find a really interesting thing that I hadn't heard about. There's a global voluntary measuring database that was set up in 2021 to measure the EMF health of cities. And that was born really out of the idea that there are probably cities who want to just find out the health of their city and have a volunteer and then follow the protocols using the recommended measuring devices, and then upload that information onto a website. Dr. Magda Havas is a national leader, and she's spearheading it. And the website's globalemf.net. And I just recommend people check that website. And you know, governments really establish guidelines, but like he said, few monitor those on a regular basis. It's like traffic laws, but there's no enforcement. So these people, the volunteers, will monitor over a period of 5 to 7 days, or they did so over a 24-hour period. And so far on that website, what I can gather is that there have been 135 volunteers monitored to 263 sites in 16 countries. So this is like a global effort, you know, that's happened.
Okay. So,
Oh, and by the way, so Stevens Point and Washburn are the two I found in
Oh.
Wisconsin that are rated low in EMF exposure. And so this website, I mean, I would urge us to be one of those communities that find a volunteer, get the direction to measure our own city from them, get that uploaded, and put Oconomowoc on the map. And I think it would be great for residents and future residents to see, like what our measurements are like. And it's like, well, we don't really have to, you know, we don't have to do anything but volunteer for it.
Peter says he'll do it.
Yeah. Citizen science, citizen engineering, love it.
That's exactly what it's about. So,
No, that's really interesting, and he did mention too, you know, I feel like we are really on the cusp with this topic. He mentioned cigarettes, thought they were safe, asbestos in people's homes, and then all of a sudden the experts come out, and then now you have to have testing for asbestos if you're going to remodel or tear a house down, you know, whatever, and that was thought to be safe too. So I feel like when you're talking about some of these testing abilities, that we really are on the cusp of this, and maybe we could be one of those communities that is an example to others around us. It looks like the East Coast is doing things with this topic and a lot on the West Coast, and here we sit in the middle, you know? But we have an opportunity to maybe bring this to light and do something with a change of ordinance and with some testing.
What my research in kind of following up with what I was charged with has been leading me to is that it's a bigger issue than just managing cell tower frequency, wattage, measurements. That it's really about finding safety for our residents in wherever they are in their communities, that it's a real personal thing. And, it was suggested by one of the experts, why don't you, find a way to set up safe zones? Propose to your leadership to come up with safe zones where people who are sensitive can find respite. Like, what about our parks? And then have that be a guiding force in the kind of ordinances that we have. So there's getting meters at the public library, having, I think really, the technology committee could do some really, really great work with educating our public.
I mean, I'm thinking like with our ordinance, when we pass this on, what is going to be like the meat and potatoes of our ordinance? I mean, you mentioned those topics, and I think that's really important. When he was talking about when we need to show, those high levels, what are those high levels? And that's proof, that, I mean, I'm just saying, how do we structure this ordinance as we send it on to the council?
Well, I mean, the way this would work is
Sorry.
that it will go on to council as a recommendation for us to engage with Mr. Campanelli, and then he would be the one that structures that ordinance for us, that 47-page
Okay.
document that he was talking about. And then we would have the opportunity to revise that if we needed to.
Okay, and then how does that revision work after he puts it together? I mean, what are the things that we can revise? Is there?
That I don't know. That
Okay, I don't know. I'm just asking.
Yeah, that's a good question, and that I don't have an answer to.
Just
But-
trying to,
Yep,
centralize this and, moving it forward.
Yep.
And it appears that's what we, plan to do.
Yep. Yeah, good question. Any other questions at this point? Of Jill? Thank you for doing that. I had a feeling we probably weren't going to find much, but I think that's just proof that we are on the cusp of this and that, and this is a good time for us to start looking at this and being proactive with this topic. So, all right, so if we're done with that, I'll move on to number 4. Do we have any comments and suggestions from citizens? Does anyone want to say anything before we close the meeting? Please. Sure. And just let us know your name and quick little background.
Hi, my name is Bob Johnson. I live in Oconomowoc and have for 25 years. And I am in the learning process because I'm the lay leader at a church here in Oconomowoc. And we were approached 2 months ago by a cell tower locator company on behalf of Verizon. And they have offered us to potentially look at the possibility of putting up a cell tower. And I've never bought a cell tower, I've never leased one, so I'm in the process of learning, so that's really why I'm here. And, quite frankly, I'm a little shocked at how adversarial this is. And from a standpoint of, this attorney is at war with cell tower companies. It's obvious. He's selling his service in a big way, and he's trying to shock and awe you and me to the fact that if you don't use me, you're going to be screwed going down forward. It's just, it's unsettling to a citizen to hear. Can't we just find out what is the science? Yes, let's measure the wattage coming from these cell towers, and it should be black and white. Either they're safe or they're not safe. I don't understand why there's got to be all this, and it's almost like COVID, should you or shouldn't get a vaccine? The experts haven't decided. And he's basically calling the FCC incredibly incompetent. He said they're useless. It's just, you know, on the other hand, our church, like a lot of churches, could use an extra $1,000 a month. And if we put up a cell tower, and I've seen pictures of cell towers that look like a cross. They look really cool. And so I've got a lot more to learn. And I respect what you guys are doing. I mean, if there is an issue with the exposure to the, you know, being too close, and I mean, it's not like you always have to trust the government, but if the FCC has a limit, why not just measure that on a every year basis? And, you know, so that's my comment. It just seems like it's incredible. It's almost like a school board and the teachers. You know, you immediately are fighting. Doesn't that seem like that way to you too? It's just, I mean, gosh. I mean,
Thank you for your comments. It is a controversial issue at this point, and there's a lot that we're all learning, but one of our goals as committee members is to keep our community as safe as possible.
I respect that.
So
and
we're
I am
exploring-
I'm glad you're here
So we're
looking
exploring
at
that. And I think Ron, this generally isn't a
Wanted to
give or
say
take, but
something.
I think Ron had a comment maybe for you. and
Sure.
Yeah, I
you okay with
mean,
that?
I understand he was definitely selling his service. I mean, that's definitely what they do when they, but the point, I mean, if you look at what the FCC regulated in 1996 they basically told or wrote it across the board that communities really had very little rights, if anything. Our city attorney basically said, my hands are tied
Yeah, I
when
met
it
with-
comes to the FCC.
I met with Jason
Yeah, and-
yesterday,
yeah,
actually,
and-
your city planner.
Yeah, and the
and
other side of it
told me
is, this
about
is
that.
big money. This is huge money. This 5G rollout, when you consider that every person has a computer and every person's gonna be moving up to 5G, and I pay an astronomical amount of money just for that, but it's all about the money. These cell companies and these, I mean, they don't ever say, oh, by the way, this could affect you. I mean, they're not doing studies to show that it could affect you. They're basically showing anything that they can. It's really the big money side of it that I think really comes against you. And yes, you can get $1,000 for a tower, for having a tower in, but if it affects your churchgoers, I mean, we have a cell tower right now in a school, and a number of people in that school left because of the dangers of having that tower over their
Yeah,
children every single
Yeah,
day.
I know,
So-
St.
I've
Paul's,
seen the
yeah.
map of
Yep.
Would-
the city.
Which church do you belong to? Do you mind if I ask?
Sure, the UCC Church on Concord.
Oh, sure, okay.
Yeah.
Peter,
And I'm not for it or against it. I'm trying to find out.
right, and I'm
I'm
glad you're
trying to do my
engaging.
fiduciary duty to say,
Yes.
because on the other hand, I don't think I should just immediately say no because, I mean, it's $1,000 a month.
Yeah,
I've
well,
got a fiduciary, duty to my church to look at it. Is it a good deal or isn't it a good deal?
and you're doing your due diligence, and
Yeah, that's why I'm
that's
here, is
wonderful.
to do
Yep,
due diligence, exactly.
And Peter, did you have a
And I
question?
think we all welcome your interest and to tag along with us as we learn this. Additionally, I think that it's important to recognize that this potential provision would not be precluding you from putting a tower up. It would just provide you with the safeguards so that if they decide to boost the signals above FCC rulings, that you have some opportunity for
Oh,
recourse.
I wholeheartedly agree with that, yeah.
Yeah, that's a great way to
that's-
put it. Well, thank you, Mr. Johnson.
Yeah, you bet.
Thanks for speaking. Nice to meet you.
Thank you.
Jane, did you have a comment? I don't know if the other members know you, so introduce yourself.
Good evening. My name's Jane Owen. born and raised here, don't live in the city right now, but my family still owns property in the city, so I consider myself a stakeholder. I'd like to add some information for Mr. Johnson and Mrs., is it Underwood? Unger, thank you. The science has been testing radiation use since the 40s and 50s, both here in America, major universities in Europe, Germany, Russia. Its use in war, which we have used, and I'll use that very loosely. Many countries have used it. I'm a military veteran. There is no safe minimum, none, zero, for RF radiation. And if they're only offering you 1,000 a month, you should be able to get exponentially more than that. And they can add on, once you put up that starting infrastructure, tower, whatever it may be, they can add on a lot more and they can turn it up as high as they want until you catch them and stop them. 6G is already operating in Wisconsin. 5G is all over southeast Wisconsin and Madison and has been for years. So we're already exposed to it. There are already side effects to it. There are people in town who have to have no electronic Wi-Fi in their home. No, not everybody owns a computer. I don't own a computer. I know how to use it. I was electronics and security in the military. I refuse to own a computer. Yes, I use a cell phone. And I extremely limit what happens with that cell phone. We also have landline on purpose, so it's much harder to track who calls in and out and what they do with it. We're lucky that in Wisconsin, with AT&T, we can still have landlines. Many states do not have that option anymore. Also, you mentioned about the Midwest is not doing as much and it's more out on the coast. That's not true. There are many groups in, for example, very highly conservative Montana, one of the most conservative states in the nation, that are going after the state for protecting their right to life, to clean air, not polluted with RF radiation, whether it's car exhaust, whatever it may be. That's their right to life and nature. And they're actually trying to get it personhood, like some companies are granted personhood to protect people's right to live. And with that tiny little population in Montana, and as rural as it is, but they do have a fair amount of money, yes, things are happening in the Midwest, north to south. It's not just a couple one-off cases here and there on the far coasts. You just have to listen to what's happening and be alert and situational awareness for it. And it has been happening for years. And you have to be open to seeing what and how and why they think that way and what they're doing for their people. But there is no safe minimum on this, on any radiation, not just RF radiation. There is no safe minimum. Research the scientists, the universities that study it without getting sponsored by companies paying for grants, for example, PhD and postdoc researchers. The results have been out there since the 40s and 50s and 60s. I happen to be able to read and write some Russian that I can understand them without having to pay to get them translated, and some other languages, fluent in German. So I don't have to get American translations. I can read it directly from how they wrote it and what they studied. I can get you those links and sources if you're interested. I'm happy to give you my contact information. This has been a decades-long process that we've increased this in the country. And I realize there's going to be progress, but it has to be smart progress. You need to be well-informed. Your fiduciary and duty includes your congregants and the people living around you, the nature around you. You destroy people's ability to live and the nature, the water, the greenery here, so much for your congregation, no matter how much money that cell tower company and Verizon pays you. It will
Jane?
be gone.
Jane, do you want to meet with Mr. Johnson after the meeting?
Sure.
We're gonna move on. That'd be wonderful. Thank
Thank
you
you.
so much. Thank you. All right, item number 5, set future meeting dates. Right now we have, yes. Oh, Elaine. Yes.
First of all, I want to acknowledge that I'm really impressed with your technology committee. And I visited your website, and I love how you have on your website different locations of the cell towers in your community. I haven't seen that in any other community, so I think your committee's doing a great job. For Mr. Johnson, I have a letter that I can share with you. It's been in my binder for a little while. It was a letter written by Environmental Health Trust by Dr. Deborah Davis. She was on the committee who helped stop smoking in airplanes. So she deals with environmental toxins, and she is the founder of Environmental Health Trust. And in 2019, I asked her to write a letter to Governor Evers because I was among a group of citizens who went to Madison to testify against the 5G bill. And unfortunately, despite all our effort educating Governor Evers and his team and going and testifying in back-to-back hearings, he decided to sign the 5G bill. And you can read a little bit more about that on the first page of our website, wisconsinsafetech.com. But I'd like to just give this letter to you because it has all the research. Now, again, I think I mentioned to you earlier, this is independent research, thousands of studies that show the harm from wireless technology, and that includes the Wi-Fi in this room and our cell phones. And, you know, it is all around us, but there are measures we can take to protect ourselves. For instance, in my house, I don't have the Wi-Fi turned on. I downgraded from a smartphone to a flip phone, which I actually left on my island because I charged it and I thought I should have it for this long drive out here. So, you know, there are things people can do to try and protect themselves. And as Andrew Campanelli indicated, there are people who are extremely sensitive to the radiation. And there are studies that indicate the closer you live to a cell tower, the higher the risk, and in particular, brain and breast cancer. And we were fighting in our community a cell tower on church property, and unfortunately, it went to court. The Village of Greendale lost. The group of activists tried to support our village in fighting the tower. It was built, and one of the activists who put a flyer on my door back in 2016 to get the ball rolling to fight this church cell tower is now suffering with breast cancer, and she lives across the street from this. So I encourage you to visit Environmental Health Trust and take a look at this. And all the references are in this letter, so you can have this.
Okay. Thank you.
And thank you for coming out. It's
Okay.
amazing that he's
Yes,
here to
yes,
learn.
I appreciate it. Thank you, Elaine,
right,
for your
you're welcome.
comments. Appreciate it very much. And obviously, you two can make some connections there and keep in touch with each other if you need to. So, all right, back to number 5, set future meeting dates. We're going on a quarterly basis, as you know. I'm trying not to do like strict, like end of March, the strict quarters like that. We're kind of, you know, throw it off a little bit. So we're, for anyone who has a lot of other things that are on a quarterly basis. So February 28th would be 3 months from now, though, and then May 30th would be another 3 months from now. So those are our tentative dates. Anybody have any reason at this point that those wouldn't work? Okay, sounds good. I'll take.
When is the
What?
Memorial Day?
Oh, yes, I did look at that. I think this is, I can't remember what day of the week is this. Can somebody look up May 30th? Oh. It's a Tuesday? Okay, since we usually meet on a Thursday, do we want to change then to that same week, but Thursday? Maybe that's a good idea. What would that be, June 1st? Okay, well, let's do June 1st. That still keeps us within that 3-month time frame. Sounds
And-
good. Thank you, Lori.
And just a question, Karen. So what will we be working on at the next meeting?
At this next meeting?
At our tech committee next meeting?
I don't know that yet. We don't, we would like updates from Lou on the parking situation. I think you and Jennifer had something on the other agenda. So we're going to try to bring those two things, and then anything else that may come up, and it may be a follow-up to the council meeting with Andrew Campanelli, that suggestion.
And the citizen scientist,
Yes, yes. So that's what we have for now. I will take a motion to adjourn.
I'll motion for.
Second?
All in favor?
Aye.
Aye.
Thank you guys for coming. Thank you so much. I appreciate it. That was